Mets-toi juste là.
Chief Justice, Justices, I suspect I will not be allowed to speak uninterrupted this morning, so I'll get right to our argument. We have 5 points to make. First, we want to explain the basis of deferential review, why we have judicial review, why it must be deferential in principle, and as I will suggest, that probably requires the court to refocus its understanding and presentation of the principle of legality. Second, we want to describe the ways in which deferential review should be practiced. Third, we want to highlight the fact that the legislator may legitimately opt for a different type of relationship between courts and the administrative state, as expressed in provisions granting statutory appeals. Fourth, we want to identify some limits to the principle of deference that are dictated by a conception of the rule of law that arguably extends past the principle of legality to reach principles of consistency, for instance. And fifth, we want to address these limits as sites for non-deferential review. I will be addressing, time permitting, the first 3 points, and Maître Bochter will address the latter 2. We've split our time in half. And I will be making my remarks in French, but at the risk of complicating the life of interpreters and people in the room fiddling with headsets, I encourage members of the court to ask questions in a language that enables them to best express the nuances of their thoughts, queries, and concerns, and I'll answer in whatever language is handy at that point. Alors, permettez-moi donc de passer tout de suite à mon...
So I'll move to my first point immediately, and I'll do it relatively quickly because I think that we already understand the basics of the 3 paradigms that I want to raise. We've heard 23, I think I'm the 23rd lawyer to speak here today. There have been divergent opinions expressed,
Même sur le banc.
but there is consensus even on the bench when it comes to the rule of law and the principle of fairness. Any power is delegated. All acts have to be legitimate. It's up to the courts to ensure that that legitimacy can...
And Saucin, no administrative act may lay absolutely outside the purview of judicial review and interference. Crevier, d'ailleurs, offre une garantie constitutionnelle.
There's a constitutional guarantee of this principle. Historically, conceptually, and even over the last 3 days, we can conclude that there are 3 different versions of this principle in confrontation. In our opinion, the current jurisprudence is unstable because it lives in the uncomfortable space between these 3 paradigms that are in confrontation. We believe that we have to choose one of these. The time has come to choose. What are these 3 versions of the principle of equality? The older version, that I would call jurisdictional paradigm, the principle of equality, of fairness, means that decisions are legitimate if the decision maker does not go over his or her jurisdiction. It is passive. In fact, it rests on the verification of the intent of the legislator, so we're within the jurisdiction and the decision is not reviewable, or you're outside the jurisdiction and the decision is reviewable. Question: when you talk about exceeding jurisdiction, does that take for account that the organization has the power at the outset to get involved in a case and could lose its jurisdiction throughout the process? Or does it mean as well that they may not have the power to issue an order, for instance? Answer: your question has to do with the definition of the true issues of jurisdiction. We'll come back to that later. My friend Ms. Bochter has an argument, a detailed argument about that. The notion of jurisdiction is not a useful instrument. It's very weighty when it comes to the concept. It has a long historical pedigree, but it is no longer in step with the reality of today, either because it's insufficient judicial review goes far beyond jurisdictional issues. And it's also indeterminate because, in fact, we're able to determine all the questions that are subject to judicial review. Question, I know you'll talk about statutory appeals, so maybe when you get there, keep in mind that the legislator, even today, in clauses about that, refers to questions of law or questions of jurisdiction. One must assume that they still exist. Answer, yes, we'll get to that when we talk about appeals. We're talking about a dialogue between this court and the legislator, which is not always a quick dialogue. There may be a bit of a delay when it comes to the legislative text, which means that some notions like this one, which no longer have the same scope for the court, still have status in legislative text. Question, is it your pretension that issues of jurisdiction have disappeared, or that the concept is not useful anymore? Answer, it's no longer useful. It no longer helps us determine the appropriate standard of review. I think that if you look at Justice Cromwell's reasons in Alberta Teachers, there's a lot of useful information on jurisdiction, but I think we've reached a point where that concept no longer has the conceptual power necessary and doesn't allow us to advance in this issue. Question, is the concept of fairness useful? I ask the question because you said
used to be the concept that were used in the old decisions,
right,
when they said you've lost jurisdiction. So I'm trying to say to myself, what does legality add to the conversation?
I think, Justice Abel, I think the concept of legality is still central to our understanding of judicial review. It's not the only place that we need to go to justify judicial review, but it's still central. Well, let me explain. I think, again, I think there are three paradigms at play here. One paradigm is jurisdictional.
Yeah, you didn't have a chance to do your other two.
One paradigm is jurisdictional. That one, I suggest, is no longer very helpful. That's the old version of the principle of legality. I think a second paradigm, which is obvious in the conversation that we've had over the course of the past 3 days, is a legalist paradigm. And that legalist paradigm does not go to jurisdiction. It goes to whether the decision of the administrative decision maker is consistent with law, correct in law. And that's, I think, a paradigm that rests on a hierarchical conception of the relationship between courts and administrative tribunals. The third paradigm is the institutional paradigm that rests on a conception of the administrative state and tries to understand the principle of legality from that point of view. But if you understand the principle of legality from an institutional paradigm, from the current configuration of our administrative state, it takes a different shape. It cannot be just verifying that you're within jurisdiction, and it cannot be just verifying that you're right in law. It has to be something else.
But that's why I know philosophical foundations are really important to this conversation, but what do we add to the conversation about how to assess what tribunals do by saying it's correct and therefore legal, or it's unreasonable and therefore illegal, or it's incorrect? So I want to know what the value added is of this component of legality, because we never say a decision of a tribunal is illegal anymore.
And I think I'm going to end by suggesting that you not say that either. It's still the principle of legality in a different form, but I think you should say legitimate. It seems to me that at the end of the day, the purpose of judicial review, which is to control the legitimacy of administrative action or the exercise of administrative power, needs to be done by the courts. It's structurally similar, if you like, to the old principle of legality, but it's shifted its impetus.
But surely the source of the legitimacy is in the law.
The source of the legitimacy is in the law, generally speaking. I think the source of legitimacy for the administrative state needs to be in the quality of the decision that is being made. And that rests, I think, on the institutional paradigm that I would like to present to you. Je pense pas que j'ai besoin d'insister beaucoup sur le paradigme légal.
I don't think I have to speak at length of the legalistic paradigm. Several people have argued that you have to treat like cases alike. The decision maker is not authorized to make mistakes on questions of law. All of that has to do with the legalistic paradigm that rests on the fundamental rule of tribunals of being the exclusive or ultimate interpreter of the law. Correctness of all questions of law rests on this idea. Based on the work especially of John Willis and this court's decision in QP, this hierarchy was put into question. If I were in a classroom with a PowerPoint, I would change the slide to show a different configuration, because the legalistic paradigm rests on a hierarchical vision, a pyramid, at the top of which are courts. But if you look at an institutional paradigm, you have to imagine that there are two parallel circles. There's a horizontal relationship between tribunals, between courts rather, and the administrative state. And courts have taken into account the existence of the administrative state. Question, even so, of course the administrative state exists, so we do have to take it into account, but when did we stop being this hierarchical situation? When did we begin being in a horizontal relationship? Answer, I'd say that when it comes to the court, since QP. On the ground, however, it's been much longer. The administrative state has existed since the beginning of the 20th century in Canada. It's an autonomous structure for governance that is founded on premises that are completely valid to implement public policy. Administrative tribunals play several roles, often at the same time. It's a space where decisions are handed down in processes, forms that are more sensitive to context, more rapid, more efficient, more pluralistic, simplified. It's a completely different legal order that is parallel to the one that you are at the top of. So I think when I say we have to switch slides, move from the triangle to two parallel circles, we have to admit that administrating the law is a shared responsibility between the courts and administrative decision makers. So what does that lead us to? It leads us to understanding the role of judicial review, the principle of legality, based on the theory of administration, its administrative goal. Judicial review in this context has to be redefined. The objective is no longer to maintain administration within authority that was conferred to it, the jurisdictional paradigm. It's no longer to make sure that its decisions respect the law. It's rather to ensure the legitimacy of this exercise of power. And I think the court made that decision in QP. That is when this changed, and the principle explains the principle of deference. I think it's important to remember two things when it comes to judicial review. It's meaningful. I think you, Justice Brown, pose this question. It has to be meaningful judicial review. So it's a judicial review that is true, that seeks legitimacy, and we believe legitimacy exists when a decision is handed down in a reasonable manner, transparent manner, in good faith. I said that the three paradigms coexist in an uncomfortable way, and the elephant in the room, I believe, is that each and every one of us adheres to one of these paradigms. Each and every one of us chooses one of these paradigms in our conception of the relationship between the courts and the administrative bodies, either a horizontal or a vertical relationship. And the result is that nowadays we accept the idea of deference. Your jurisprudence rests on a presumption of deference, I would say. And I say presumption of deference because in the current regime, this deference is an anomaly. Because we have held on to this legalistic paradigm especially. Edward Clark says,
There's a vigilance and restraint. Vigilance and restraint. The process of rebuttal of the presumption of deference breeds uncertainty and litigation. C'est ce que Bell, NFL, a plaidé devant.
That's what Bell and the NFL argued, and I agree completely. I would say jurisprudence will never find stability as long as we stay in this contested space. We have to make a choice. And I would even say that we have to make a normative decision here. There are no constitutional principles that ban the devolution of power to non-judicial decision makers. Nobody here has argued that there's a constitutional imperative here. There were arguments that there's a strong presumption, that it gives a better idea in our constitutional framework, but nobody has been able to identify a constitutional principle, I don't think it exists, that would forbid the delegation of power to an administrative decision maker. Question: we can control legality through a mechanism that allows for deference. Answer: if you accept that legality has a different meaning, that legality isn't only staying within one's jurisdiction, it isn't just giving a decision that reflects the law, that is what we think of as a correct decision. Legality, in our opinion, is legitimacy that stems from the fact that a decision is reasonable. Question: do we have to make a choice between these three, or in fact do we have to combine the three? Answer: you mean the paradigms? Question: yes. Answer: I think we will never be able to completely eliminate them. It's too ingrained in our legal history, in our roots in British law. I think that the legalistic paradigm and institutional paradigm mean that we have to make a choice between and choose one of them. I've heard many arguments today that show that the paradigm exists. It's logical. Judges make decisions when it comes to questions of law. And look at housing. It works. But the cost is that we have to turn our backs on 40 years of jurisprudence from the Supreme Court of Canada, and it also leads us to have an unnuanced view of the administrative structure. Question: there's constant mention of the two pillars that are at the base of administrative justice: institutional design and also the rule of law. In my opinion, one must not be abandoned in favor of the other. When you talk about the institutional paradigm, if we give it as much importance as some have argued we should, then isn't there not the risk of forgetting the rule of law? Answer: I don't think so, because the rule of law animates judicial review. Question: but we're talking about legitimacy and not legality in this case, correct? Answer: exactly. I think we have to set aside the issue of legality. If we were still in that paradigm, administrative tribunals would be within the court hierarchy. And to answer your question, Justice Rowe, things work. They're not working so well nowadays because we're constantly trying to find a way to come back in a way to a situation that better reflects the hierarchical paradigm. So we are able to accept the situation when legislators clearly delegate power through a privative clause. We accept devolution, deference, when there is a court that is an expert, a tribunal that is an expert on its home statute. We also accept it as long as the administrative decision maker is similar to a judge, has characteristics of independence, has a process that looks like an adversarial or judicial process. We're constantly trying to explain why deference should be conserved, because we're uncomfortable with the possibility of having a more generous scheme where there would be a less strict review process within this paradigm. So I think the only way to get out of this dead end is to really examine the nature of the relationship between judges and the administrative state, and to distance ourselves from this constant effort to justify deference within the legality paradigm. Question. Some of your colleagues have argued
Indifference.
that applying deference will harm the most vulnerable in our society, like prisoners, for example, or other very vulnerable people, and that we need more rigor and a stricter rule of law for people in their situations. What do you think of that? Answer. Two things. First of all, it's important to see the administrative state not as an adversary, but as a partner in the administration of the law. In some cases, it's important to encourage and even to discipline the administrative apparatus in order to enforce its credibility. So I think we have to accept that the administrative apparatus be more autonomous. The second thing I would say, what you've raised is interesting, because when you look at the interveners in particular, we can see that for the progressive interveners, with all due respect, there's a lack of confidence in administration that is the complete reverse of what led to the emergence of administrative bodies. At that time, at the beginning of the 20th century, people had lost confidence in the courts. That's why there were conflicts, privative clauses. That's why people like John Willis argued that we had to let the administrative state do its work, that things were too slow. Answer, correct. Yes, so I don't know if it's possible to have absolute confidence throughout time that courts are better guarantors of fundamental rights than the administrative state, which is subject to guarantees of legitimacy and that would have obligations of legitimacy imposed upon them. So, what does this change when it comes to the jurisprudence created by Dunsmuir? There are blogs, many blogs about what's happening today in this court, as you know, and in one of the blogs it says that our factum distributes Halloween candy. Another blogger has said that we've rearranged the deck chairs on the Titanic.
Is a shift in perspective. What we're suggesting is that, and I'm going to Justice Gascon's question, what we're suggesting is that this is where your jurisprudence leads you. On ne peut pas retourner en arrière sans...
But we can't go back in time without there being any problems. I think your jurisprudence is leading to something clear. And what are these changes that the jurisprudence is leading to? First of all, we have to stop constantly asking ourselves what the specific legislative intent is of a specific administrative regime. We're talking about a general democratic intent on the part of the legislator to create an administrative state. We have to stop focusing on the expertise of a decision maker. That's the wrong question. Expertise almost systematically favors the court when it comes to questions of law or statutory interpretation. And that means the principle of deference must not depend on the characteristics of the decision maker or the nature of the question. I have 5 minutes left. I think I will rely on my factum for the question of appeal. If you have any questions, we can certainly answer them. I'd like to talk about the reasonableness review, because of course there has been much debate about this issue over the past few days. How do you implement deference?
De déférence.
Once you've established the principle of deference, subject to the other principles that Ms. Bochter will raise in a moment. How do we implement deference? I would say that, first of all, deference is, first and foremost, a posture. That's what was said in Dunsmuir. It's an attitude of respect. Of course, it was a different context, a different standard, but I think most appellate judges, or all appellate judges, really understand what deference means. When an appellate judge studies the conclusions of fact of a trial judge, he or she positions him or herself in a position of deference. I wouldn't say that the standard is palpable overriding error. I would say that we're dealing with what is essentially an attitude. And in Saint-Germain v. Blenheim, I believe, Justice Wagner wrote the reasons and quoted Justice Morissette in the appellate court, who was talking about these issues. So, in my opinion, there are 4 ways of dealing with reasonableness review.
Readily available to me in that context. So I would say there's 4 ways to do reasonableness review. One way is to look for badges of unreasonableness. So once you get to reasonableness review, you might want to say, we'll make a list, right? It's not going to be a complete list. It's just going to be an open-ended test. We'll make a list of the kinds of things that we can see will constitute unreasonableness. And you know from experience that if you do that, this will turn into a checklist for reviewing judges. And a checklist that will not be that different from the old grounds of review that existed in old administrative law. And in a way, that's just reintroducing through the back door the formalism that you will have just kicked out of the House. I don't think that works. I don't think it would be a good idea for the court to do it that way.
Failing to take into account relevant factors and taking into account irrelevant factors is still a problem.
It's still a problem, and I think I'm going to get to how that could be inserted into reasonableness review. But I think it would be dangerous for the court and probably counterproductive to say, here's a list of the things that would constitute unreasonableness, and these 2 would figure in there. Right? It would bring us back to administrative law of the 1950s, where we had grounds of review that were quite formally defined and on which people debated extensively. So the second way is to suggest that there's a scale of reasonableness that will vary. And this morning I was in my hotel room, and there's an espresso machine in my hotel room, and if you open the box, there are little pods in there, and they all have numbers, right? It's number 1, number 2, number 8 if you're really a caffeine addict, and so on, right? That's what the scale of review looks like to me. And I don't think you want to move to a formal level of determination of the standard of review that rests on multiple factors that taken together will bring you to 9 different layers of reasonableness. I would not know how to be seriously deferential, less seriously deferential, halfway between deferential. I don't think that can be done.
Well, maybe the reasonableness is informed by the content. We don't need to get too granular.
Exactly.
About, establishing different levels. But different cases bring different considerations to bear on what is reasonable.
I think that's absolutely right, Justice Brown. That's exactly what should be done by this court. And that means that you need a contextualized single standard of reasonableness, one that will take into account those kinds of things that point to failure to consider relevant factors, one that will take into account failure to interpret legislation effectively, one that will take account of the context, nature of the decision maker, and so on. But I come back to my starting point.
So if it's contextualized, can it be single?
I think contextualizing is...
Or is it just a single name that you're giving it? I mean, it doesn't have to be called reasonable, it would be called, review.
It is review. I mean, it's review, but review that takes a very different starting point. I don't think it's meaningless to say, I can review this and decide for myself whether this is right or wrong.
Right.
As opposed to, I will review this, but I really have to pay attention to what has gone on before me, look at those reasons, see whether that outcome, those reasons that I have before me, are reasonable. And that's a
That
contextualized
outcome
assessment.
on that question?
I'm sorry?
On that question?
Meaning
Is that a consideration? The type
whether it's
the type of-
statutory interpretation or discretionary.
Or, yeah.
I think the risk there is, I think it's relevant consideration. It's one element of the context.
So we can't leave it out then.
I think it's hard to deal with judicial review without addressing that aspect, but that runs the risk of taking you to something that you've done in previous jurisprudence, which is to ascertain what is the range of reasonable answers and see whether the decision fits somewhere in that place. It's hard not to do that.
No, well, yeah, I suppose you have to be conscious of that,
Mhm.
assuming that's a bad thing. But, for example, if you have a question that is really a mixed bag, question of fact and law, whether this person is, fits within the legal standards such that they're entitled to a benefit or subject to some kind of sanction, right? As opposed to a grant of a provision of a statute granting authority to make delegated legislation or something like that.
So I think in both cases, it's the beam in your eye, right? It's not the needle in the haystack. It's the beam in your eye that should count. I was telling my students last week that I was coming here. My class is statutory interpretation. And I can tell you...
That must be a thrilling
It's fascinating.
Yeah.
I have to tell you that at the end of the class, there are very few students who think that there's a single answer to any issue of statutory interpretation. Obviously, that's something that you're fully conscious of, right? So the beam in the eye idea, it doesn't take us to patently unreasonable, although personally I think we'd be better with that. I mean, I don't want to say that because that's not our submission. But the beam in the eye, right, the attitudinal dimension of this, the posture of respect that you must have for the decisions of the administrative decision maker, I think that's the right position. And it's not meaningless words. You can add multiple words to this. You go Wensbury standard, arbitrary, capricious. I don't think it adds much to the idea of a starting point of respect for the decision maker.
But the question I have is, where are you putting context conceptually? Because what I thought I heard you saying is that you don't put context in determining how intense the review is going to be. In other words, it doesn't go to the job that I have to do, at the nature of the job that I'm doing. I understood you to say that context goes to informing what is a reasonable decision.
Absolutely.
And so it's a question of what the tribunal, the decision maker, had to be keeping in mind as the tribunal, the decision maker, reached their determination. Have I fit it in the right place conceptually?
Absolutely. I have nothing to add to that, and with the Chief Justice's permission, I will sit and allow Mr. Doctor to address the rest of us.
Does that mean she's going to speak about appeals?
Well,
Because I think that is something, I thought you said you were going to deal with that, but I really have some questions.
So, if Mr. Doctor will give me 1 minute, I think here the dilemma is it looks complicated. I think in the end it's fairly simple. If you start from first principles, it's hard to accept the idea that a statement in legislation that points to appeals means judicial review. I think there's some meaning there, right? If you start from first principles.
The first principle being legislative intent.
Well, that's the place where we think if there's explicit legislative intent, I think it needs to be respected. There's no constitutional imperative that requires that review be deferential. I mean, there's no such thing. I don't think it's entrenched or constitutionalized. It's not in the same nature as primitive clauses in that sense. It doesn't raise the same kinds of issues. So I think it's hard to accept the idea that the legislature has said appeals, it doesn't mean appeal. Of course, all of that needs to be situated.
How do we explain, and that's the big question, how do we explain our past jurisprudence?
I think your past jurisprudence, with all due respect, I think on this, your past jurisprudence may have to go. I mean, there will be broken eggs.
I hear you. I just want to have an understanding because, as you put it, it's not because the Supreme Court in 2018 decides to look at judicial review that everything else goes. There has to be a principle basis for us to say, well, something has happened that makes us reconsider or review. Certainly not because this court so happened to be those 9 people, because otherwise in 5 years it's going to be different.
Right. So I think there are two possible ways to answer this. The first is that if you go back to Dr. Q, for instance, which in my view is pretty close to the starting point of that jurisprudence, that rule, or principle or idea, is expressed in a single sentence. And I can't find a justification in there for that.
Well, Dr. Pessim was the start.
I'm sorry?
Pessim, Dr. Pessim.
Pessim is the start.
Pessim is the start, and there's quite an extensive justification.
But the justification there relates to preserving the authority of administrative decision makers, relates to their expertise. I think all of that should be out the window. Looking for expertise as the foundation for judicial review is not the right site. I think it has to be in the existence of the institution itself.
How do you describe the reason why that fairly consistent line of cases is clearly wrong, so that we should be reversing our jurisprudence? Like, why is it clearly wrong?
So again, I would say here there's no constitutional imperative. You can do whatever you want, right? But our position is that the more consistent response, in line with the principles that we've outlined, is to say that appeals mean appeals. You might say, well, look, one possible answer that would go in the other direction would be to say, we can't really do that. We have established jurisprudence. And because we've wavered on those kinds of issues, because the jurisprudence of this court has taken a while to evolve, and we're dealing with clauses in legislation that predate some of these changes, it's not logical to assume that this represents legislative intent. That's one of the things that was suggested to you over the past couple of days.
Yes.
But we think, and I really want to close because I see that we have 23 minutes. And
Vous allez avoir plus de temps, mais justement.
Merci. I'm sorry, go ahead. You were going to ask.
Go ahead and finish your answer if you want. I'm in the same ballpark.
So I think, you could go either way, but I think the more consistent understanding of what's going on here is that legislative intent here can be relevant and can point to a different kind of relationship from the one that I've outlined in that institutional paradigm.
But in your sorry to interrupt.
On peut faire ça en français, monsieur Gascon.
Je veux juste qu'on me suive.
In the framework that you're proposing, you talk about a deferential rule. When you see that there's a clear legislative intent, what does that mean? Does it mean that in those cases there is no deference? Answer. It means that through that text, the legislator has constituted a different relationship between the courts and the administrative decision maker in question. And whether I'm right or not, the court will have to decide this issue. We'll have to give clear indications on what constitutes a legislative intent where deference is eliminated. When there's a principle of deference, you're going to have to be clear on the words that have to be used. Should it be something similar to what happens in British Columbia? Is it enough to indicate appeal on questions of law or questions of jurisdiction? Honestly, I think that any of these answers would work because, once again, we're dealing with a dialogue between the court, which establishes the framework for common law on judicial review, and the legislator that responds in a way to what the court is saying. For the same reason that we couldn't be absolutely certain that all forms of appeal in the current law are indications that deference has been abandoned, we couldn't do that unless the court gave specific instructions on what constitutes a different structure and different relationship. Question. Justice Martin and Justice Abella have questions.
If we accept your premise that it should be a paradigm based on legitimate decisions and the things that you say should be embraced under that, what is the role, or what is the obligation, I guess, and is there a duty on decision makers in administrative tribunals or administrative decision makers to give reasons?
So, yes, I would say quite strongly, actually, that one likely outcome of the proposal that we're making is that there will be more cases in which decision makers, administrative decision makers, will be required under Baker to provide reasons. It's inevitable, right? And I go back to Maître Macklin suggested to you before, which I think makes perfect sense in many respects. If we go into this culture of justification, which has been one of the important dimensions of scholarship on judicial review, it has to put a larger burden on decision makers to come up with reasons. It's absolutely inevitable that will be the case. Deference starts with reasons. If you don't have reasons, it cannot really be a deferential exercise.
Well, deference calls for responsibility and accountability.
Indeed.
That's the other side. That's the side of the tribunal. That's the respect of the court, but for the tribunal is responsibility and accountability. Explain yourself.
You mean the tribunal's accountability to the community?
Yeah, the one that you review.
Yeah, I would say, but I think that points in the same direction. That points into more reasons, more effective explanations of the outcomes that people are confronted with.
I want to bring you back to the rights of appeal, because your position seems to be it's based on legislative intent. When Justice Gascon talked to you about the long line of jurisprudence, it is a consistent line from Pessim through Ryan and Koza, which said this is how we see legislative intent. So it's the dividing point seems to be how the legislative intent is interpreted. For this court to go back on how it's interpreted, what these appeal provisions are for in judicial review, seems to me a little awkward just because we feel like it, because there is one case, as you know, where the majority did say inter vita. This is a different kind of appeal clause because it says review it as if it were a decision of the federal court. So it is possible to have an appeal clause that says it, but we've said the opposite, and although it's...
So, again, I don't want to be flippant here and say that you can just overturn whatever jurisprudence you have. If you did, that would be a very interesting scholarly conversation for the rest of us on the academic side of what's going on here. So I don't want to be flippant. I don't think you can turn your jurisprudence over without some kind of principled foundation. But it seems to me, at the very least, that the court needs to acknowledge that if there is explicit legislative intent in the form of what was put in ter vita, that you need to comply with it. Right? I think ordinary people would find it surprising to know that when the legislation says treat this as though it's a federal court decision, that in fact it won't be. So I think that language certainly is very strong and good enough. What else is good enough underneath that, I think, needs to be clarified by the court. Justice Mulder?
I think you just answered my question, and rather than going back and say we got it all wrong before, why don't we just, because we're here to see what the problems are and what adjustments need to be made, so maybe we should just say from here on in, legislature, here's how you tell us when the court should get involved. It's a matter of correctness for the courts, or something like that, although somebody will probably have an interpretation of that that's different. But that's the point here. It seems to me on a go-forward basis, we want to send a message, a clear one, to the legislatures, to Parliament. Here's how you do it. You want to do it? Do it.
I agree with that. I don't have anything to add to this. Thank you.